Hello, respective viewers. I'm George from Ireland. So, carrying on with criminal law. So, I'm going to just run through some offences and take you through the process you need to go through in order to analyse a offence against a person and then categorise it correctly. So, first of all, take the victim. How serious is the injury? Are we looking at assault and battery level right up to grievous bodily harm, possibly attempted murder? And then bear in mind, what was the state of mind of the defendant? Was he or she doing this deliberately or recklessly, or did they have any justifiable defence? So there are other questions to ask. Are there any issues in relation to actus reus or mens rea? And that obviously touches on the defences you could run, like justification, self-defence being the main one. Actual bodily harm and battery are quite close. It's quite difficult to tell them apart. But remember, in R against Miller, any hurt which was intended to injure the person's health or to reduce their comfort could count as assault. And it's not something which is very temporary or so minor that we wouldn't think that it's a crime at all. Just accidentally bumping into someone in the street, something like that, is not an assault. Or if there's some sort of physical contact as part of a proper sport and done within the rules, again, that's not assault. Was there consent? Not volens non fit inuria. So as in, if they're willing to participate in this activity and they got injured, in which case there was no criminous wrongdoing on the part of the defendant. So, but did the defendant interfere with the person's health? And is this injuring the person? And remember, the very transient things are usually not held to be assaults, but how transient does it have to be? Something which causes you harm or discomfort for a second, a minute, an hour, a day, or what? It's imponderable. Serious harm, that's covered by Section 20 of the Offence Against the Person Act, or indeed Section 18. So if someone intended to cause grievous bodily harm, you'd look at Section 18 in particular. Remember this doctrine of transferred malice. If I'm trying to hit Andrew, but I accidentally hit Ben whilst aiming at Andrew, then I can say, but I didn't intend to hit Ben, I was trying to hit Andrew. Nevertheless, that's called transferred malice. My malice was directed against Andrew. I accidentally hit Ben, but the mens rea is still there. I still have the guilty mind, as in I deliberately tried to hurt another human being. It doesn't matter that I hurt the wrong one, the one I didn't actually wish to hurt. Nevertheless, I'm guilty of assault at the very least. So, we talked about battery. There's something called indirect battery, which is a bit like transferred malice. That's as per the Department of Public Prosecutions against K or R against Martin, and there's no implied consent. This is usually battery. Assault is something which is defined by Tuberville against Savage. Okay, so there are the Offences Against the Person Act, Section 23. This is about all sorts of more serious harm. It can include to the internal organs, harming people's liver and lungs and so on. People who are hospitalised, well, that's clearly serious harm. So bear that in mind if that comes up in a question. So you also have to think about the chain of causation. Is there novus actus interveniens, as in a new event, something else interrupts the chain of causation, which means that the defendant is not responsible for what happens on later. It would have to be very bad what happens in between to break the chain of causation. So it's quite difficult. Remember, the Offence Against the Person Act can go right up to murder or manslaughter. And what's the mens rea for murder? That is intentionally or recklessly killing someone, or at the very least intending to cause them grievous bodily harm. But if it wishing to, or being reckless about causing grievous bodily harm, ends up actually killing them, it's usually still murder. So the issue of consent doesn't really operate here. Even if somebody wants to be killed, requests to be killed, and is absolutely certain, even if it's sworn in front of a dozen witnesses, it doesn't matter. You can't be killed with your consent. So this here the principle volenti non fit iniuria does not operate. There are times when people have supplied drugs, for example. Someone says, yes, I want that drug, and takes an illegal drug and dies from it. Nonetheless, the person who supplied the drug is still guilty of a crime. Not murder, actually, giving someone this pill which happens to kill them, but it's still a grave crime. Okay, remember, you can usually only commit these acts by commission. Sometimes you can commit by omissions. There are duties to act. Usually, as a parent, as a doctor, as a nurse, as a police officer, as a teacher, as those who are responsible for others, you have a duty to intervene and save people where you can. Whereas there's no mutuality here. A child, including a grown-up child, has no such duty towards his mother or father. Okay, so in R against Marcus, it talks about noxious substances and how those can cause harm. So even if these are legal things, supplying alcohol, even to a minor or someone is already very inebriated or in a dangerous situation. So remember, for murder, you need the actus reus and the mens rea to coincide. And there can be several steps which actually add up to murder. It can be poisoning someone in increments, not one big dose of poison that kills them one night, but it can be cumulative over a long period of time. Nonetheless, that could be murder. Okay, so people often try to cover up these crimes. There are cases about that R against Church and R against Lebrun. Or someone, there was a case where someone murdered someone else, tried to kill someone, thought the person was dead, actually the person wasn't dead. In an effort to dispose of the body, threw the body in the river, then the person drowned. Or was that murder? The defence obviously arguing, well, he didn't think he was killing the person, throwing him in the river, nevertheless it was held to be murder. Okay, it's a bit like R against Maciella. So anyway, in R and Bollum, I think it's Bollum or is it Bollum, the court says they have to look at the situation in the round, the totality of the wounds, as per Section 20 or Section 18 of the Offences Against the Person Act. Sometimes their injury is caused by trying to run away from the wrongdoer. There's fright and flight, but if this harm that's caused by running away from an assailant leads the victim to fall over and hurt himself, if that's foreseeable, then the defendant is still guilty, even if the defendant didn't actually manage to hit or kick the person. However, is it unforeseeable? Because what the victim did to try and escape the danger was so ridiculous that no reasonable person would have anticipated it, in which case the defendant would be not guilty. There are cases which ask these questions, such as R against Roberts and R against Williams and Davies. When I say R, I mean like Regina, the crown, Regina or Regina, however you wish to pronounce it, Regina, being Latin for the queen. Obviously, if there's a king on the throne, it's Rex, as in the king. Okay, so battery, as per Section 47, the Offences Against the Person Act, that's something you see all the time. And it can even be psychological, as decided by R against Chan Fook, causing people to weep incessantly. Okay, but causation is always a key issue. So grievous bodily harm, it can be a psychological injury, as decided in R against Ireland. The person of the country can be a surname, not George from Ireland, incidentally. But it has to be a named psychological condition that's caused or at least aggravated. It can't but just be something which is very non-specific, like sadness or worry. Now, if you fail to carry out some safety checks when you're supposed to, this can also be breaking the Offence Against the the Offence Against the Person Act, as in R against Pitwood. Okay, a contract, for example, can give you a duty to act, and you can sign one of those if you work in certain roles. So causation is probably the trickiest thing of the Offence Against the Person Act. There's the eggshell skull rule, as in R against Hayward. You take your victim as you find him. You injure somebody and not realising that person is particularly susceptible to this injury and suffers grievously, much worse than you would have anticipated. Nonetheless, that is so what? That's your fault. If you stab someone in the foot, you think it's not going to kill the person turns out to be a haemophiliac, bleeds to death, well, you're still guilty of murder. Okay, so the mens rea under Section 20 of the Offence Against the Person Act is seeking to cause harm, or at least being reckless about doing it. This is R against G, for example, and that you can be guilty under the Offence Against the Person Act by an omission if you didn't show due diligence if you're in charge of someone's safety. You've got to do what's reasonable. So grievous bodily harm in Section 18 and Section 20 of the Offence Against the Person Act is something that comes up again and again. We often ask, was there an intention to cause grievous bodily harm? Well, what do you need to discuss here? Was there a direct intention or an oblique intention, as in R against Woolen? And was serious harm very likely to result, in which case it was definitely GBH. If it was very unlikely to result, then, okay, not GBH, that might reduce it to battery or even assault. Okay, remember here, the application of force is something we're looking for, and that's tricky. So you've always got to take the law and put it onto the facts and then see what you come out with. Okay, so that's just a little bit of a few case studies of how to analyse crimes which seem to be against the Offences Against the Person Act. Toodaloo.